In today's video, I want to take a look at a question that I'm confronted with on a daily basis from employees. And that is the question of, do I have a claim? Do I have a justiciable claim? Where do I stand? And this all arises in the workplace from some issue or some problem that's arisen in the workplace. The employee might feel a sense of grievance. The employee might feel hard done by. The employee might feel a sense of unfairness. But they're not actually sure whether it's them being oversensitive or a genuine breach of their employment rights. There's a 4-question test that I look at or use in order to determine and assist the employee and advise them as to where they stand, and to try to give them clarity and try to answer the question, where do I stand? Because I know that one of the biggest and most important jobs that I do in dealing with employees or employers, or indeed anybody in relation to any potential dispute, is, where do I stand? Do I have a claim? Am I going to get defeated or badly beaten in this dispute, this row, this litigation, if I go ahead with it? So I have a 4-question test in relation to employees. The first one is, has there been a breach of a statutory right? So the statute laws on the statute books, for example, the Unfair Dismissals Act 1977, the Organisation of Working Time Act 1997, and so on. Has there been a breach? The Organisation of Working Time Act, for example, makes provision for the maximum number of working hours that an employee can do over a certain period of time. It makes provision for annual leave and a minimum entitlement to paid annual leave. It makes provision for rest breaks, rest from work. So has there been a breach of a statute? It's generally fairly easy to identify whether that has happened or not. So that's the first question, or the first area of law that I would look at. Has there been a breach of a statutory right or entitlement? The second aspect, or the second critical group I would look at, is, has there been a breach of the contract of employment? So the contract of employment is going to contain certain terms and conditions which governs the relationship between employer and employee. Has there been a breach? For example, if the employment contract says that you're going to get 5 weeks annual leave every year, and the employer only gives you 4 and says, tough, there's obviously been a breach of the contract of employment. Also, if the provision in the contract for the notice period of termination of employment, for example, is you'll be getting a month's notice if I'm going to get rid of you, or if I'm going to terminate your employment, each party will give the other a month's notice, and the employer turns around and only gives you 2 weeks, then clearly there's a breach of contract. So that's the second category. The third category is, has there been a breach of a constitutional right? Not a contractual right, not a statutory right, a constitutional right. So you have a constitutional right to earn a living. You have a constitutional right to natural justice, fair procedures, not to be discriminated against, to your good name. You have a right to earn a living. You have a right to practice a religion. You have a right to join a trade union, and so forth. These are constitutional rights. Some of them are enumerated and set out in the Constitution. Some have evolved over time. They are unenumerated rights. The bottom line is, you have contractual, or you have constitutional, and indeed human rights. So that's the third category, and that's where I'll be looking as well. Final category then I would look at is, has there been a civil wrong, a tort? A personal injury claim, for example, is a civil wrong, and it is a tort. That's what a civil wrong is. Negligence, if the employer fails to discharge his duty of care to the employee, he may well be held to be negligent, and has consequences flow from that, liability flows from that, damages perhaps flow from that. But has there been a civil wrong? has the civil wrong led to a loss for the employee? Now, in a very straightforward civil wrong situation or a negligent situation, you could be looking at a personal injury claim. For example, has the employer failed to provide a safe place of work, a safe system of work, safe tools, and so on and so forth? If that's the case and the employee suffers a personal injury, well then it's quite likely that the employer is going to be held negligible or negligent and is going to be held liable and therefore will have to compensate the employee. That's a civil wrong. To recap, 4 questions. 1, is there a breach of a statutory right? 2, is there a breach of a contractual right? 3, is there a breach of a constitutional right? And 4, is there a breach or is there a civil wrong? Is there a tort, negligence, personal injury and so on? Now, if the employee cannot find his or her issue or problem or difficulty in any of those 4 categories, the likelihood is that the employee simply has a grievance. They have a sense of injustice, they have a sense of unfairness, they have a sense of grievance, they have a sense of not getting the bonus they were entitled to, not being given a day off that perhaps they felt they were entitled to and really wanted, not getting a day off for, or some other promise that may have been made to them, for example, career progression and perhaps not getting a promotion. These all lead, to a sense of grievance and a sense of unfairness. But are they justiciable legal claims that you can canvass in a court or in the WRC or in the Labour Court? No, quite frankly, they're not. Now, if you have a grievance, you can, after canvassing or raising the grievance and flying it, as it were, in the workplace and using the internal procedures in the workplace, then if you're not happy with the outcome, by all means, you could go to the WRC, bring a trade dispute, for example, and basically say that the procedures in the workplace are not being adhered to, are not being implemented and enforced by the employer. And if that's the case, then you might get some sort of a recommendation under the Industrial Relations Act 1969. But as for a bone with meat on it, a real claim, I'd be looking at the 4 categories that I've set out already in this video. So I hope you understand and recognize the importance of, on the one hand, what's unfair, and on the other hand, what's unlawful. So hope you find this video useful. If you do, you might give it the old thumbs up down below, and you may be interested in subscribing to my YouTube channel, in which I attempt or endeavour to the best of my ability to explain Irish law, employment law, business law, and so on in plain, straightforward language. Thanks for watching, and I hope, as I say, you give it the thumbs up.